I was going through this script a few days ago, and I keep returning to one moment in particular. The protagonist is alone at her kitchen table, a glass of water going warm next to her laptop. And she opens a new blank spreadsheet. She titles it Professional Notes. That is where this story actually begins, not the betrayal. The spreadsheet. Welcome back. The coffee in my hand was the wrong temperature. Not cold, not hot. That particular lukewarm that meant I had been holding it too long, thinking too hard, waiting for something I already knew was coming. Hargrove and Partners occupied the 43rd and 44th floors of a building in the financial district where the windows were floor to ceiling and the view was designed to make you feel consequential. I had sat in the managing partner's office maybe 100 times in 7 years. As a first-year associate, receiving my marching orders. As a third year, being introduced to the Caldwell Energy account. As a sixth year, being handed a client file for a man whose company had revenues larger than some Pacific Island nations. I knew the room. Else, I knew the particular way the afternoon light came in from the east-facing windows and made everything look warmer than it actually was. I knew the smell of the leather on the chairs, the specific hum of the building's ventilation system, and the way Reginald Pemberton, the managing partner, a man who wore his age in the way he leaned back in chairs, always set his hands flat on the desk before saying something he had rehearsed. He set his hands flat on the desk and said, "We're thinking about restructuring the Caldwell team." I said, "I see." That was all I said, because I already knew what restructuring meant. I had been at Hargrove since I passed the bar, not out of inertia or obligation, out of intention, which is a different thing. And yet I had researched the firm the way some people research countries before emigrating. The power structure, the institutional culture, the gap between how it presented externally and how it actually functioned. Hargrove had a reputation for promoting from within on a genuine 8-year cycle, which was unusually clean for a large firm. 2 partners per practice group per cycle. Energy and infrastructure was my group. The Caldwell Energy account was, by common industry knowledge, the credential that moved you through the final door. I had taken that account at year 3 when a partner retired suddenly and the file was bleeding. I had stopped the bleeding. I had grown the relationship from a mid-sized client engagement into the single largest account in the practice group. Us and I had billed more hours on that matter than anyone in the group's history, while maintaining a secondary client load that would have qualified as a primary load at most peer firms. I had done this while also managing a relationship with Dorian Voss, who was 3 years ahead of me, already a partner, and who most people in the building assumed I would eventually follow. I had not followed him. I had built my own path to the same door. That was what they were about to take from me. Pemberton was still talking. He had the careful vocabulary of a man who had practiced law for 40 years and understood that every word spoken in a meeting like this was a potential exhibit in a future proceeding. Delphine's background in energy transaction law makes her a natural fit for the Caldwell relationship at this stage, he said. The client is entering a phase of complex regulatory work, and we feel the team could benefit from her specific expertise in that area. Who is we? I said. He paused. The particular pause of someone who had expected a different kind of question. The executive committee, he said. And Dorian has been involved in the conversation, given his ongoing relationship with the Caldwell client team. I set my coffee down on the corner of his desk without asking permission. It left a faint ring on the leather coaster. What's the transition timeline? I said. Not, what do I get instead? Not, is this fair? Not, do you understand what 7 years looks like from where I'm sitting? Just, what is the transition timeline? Because process was something I could work with, and I was already somewhere else in my head, assessing, measuring, and moving from where I stood toward where I needed to be. 7 years is long enough to know a place in the way that you know a person you have lived alongside. Not ideally. Not as it presents to guests. The real version, which includes the drafts and the flaws, and the specific compromises the institution has made with itself over time. I knew which paralegals were undercompensated, and therefore the ones who double-checked everything because they had something to prove. I knew which partners took credit publicly for work done by associates 2 levels below them, and which ones, the rarer kind, brought you into the room and said your name. I knew which conference rooms had acoustics that carried sound through the ventilation system to the adjacent rooms, and I had never once held a sensitive conversation in those rooms. And I also knew the Caldwell Energy file better than I knew some of my own biographical details. Richard Caldwell, the client, not the company, had a specific way of speaking in depositions that required a particular kind of preparation. He telegraphed his evasions with a slight pause before pronouns. His general counsel, a man named Haverstock, who had been in that role for 15 years, trusted me because I had once spotted an indemnification clause in a vendor contract that would have cost the company approximately $11 million in a regulatory dispute 18 months later. I had flagged it at midnight on a Tuesday because I had been reading the file on my own time. These were not things you could transfer in a meeting. This was not a portfolio item you could hand over in a manila folder. This was 7 years of embedded institutional knowledge about a single client relationship. And they wanted to give it to someone who had been in the building for 8 months. Her name was Delphine. I had met Delphine Varos on her first week at Hargrove. She came in as a lateral hire at the senior associate level, which already signaled that someone with significant pull had made a phone call on her behalf. Lateral hires at Hargrove were rare. Lateral hires at the senior level were almost unheard of, given the firm's culture, not always a healthy one, of growing its own. She was competent. I registered that early and honestly. She had good instincts in transaction meetings, and she was fast on her feet in a way that suggested she had been well mentored somewhere before this. She dressed with the particular precision of someone who had been told once that appearance was a variable she could control, and had taken that advice seriously. She was also, within 3 months of arriving, having dinner with Dorian. Not the work kind of dinners, the other kind. I knew the difference because Dorian had a particular way of talking about people he found professionally useful and people he was personally drawn to. The first category he described with the cool, evaluative vocabulary of a man who had spent his career assessing talent. The second category he described differently, with a warmth that was specific to him, a warmth that leaned slightly forward in conversation and asked follow-up questions that had nothing to do with billable hours. By October, he had stopped talking about Delphine in the first category and started talking about her in the second. I noticed. I did not say anything. I filed it. Dorian and I had been together for 4 years when she arrived. We were not the kind of couple who needed constant reassurance or elaborate demonstrations. We had built something practical and warm. An apartment in the West Village, a habit of cooking together on Sunday evenings, a shorthand born of having been in the same professional world long enough to understand what the other person meant when they said, rough day, or I need to think, or can we just be quiet for a while? I believed in what we had. I want to be precise about that because it matters to the rest of this. I was not naive. I was not willfully blind. I believed in something that had been real and that I had evidence for, and then the evidence changed and I updated my assessment the way I had been trained to update legal arguments when new facts emerged. It was November when I found the receipt. Not a romantic receipt, nothing cinematic, a dinner reservation confirmation in an app on his laptop, the work laptop he left open on the kitchen counter, to a restaurant we had been to once together, on our anniversary 2 years prior, where the tables were small and the lighting was the kind engineered to make people feel like they are the only two in the room. He had a reservation for 2. It was a Tuesday. I had been in San Francisco that Tuesday. I closed the laptop. I made myself dinner. Protein, something warm, nothing that required too much attention. Then I sat at my kitchen table and I thought through everything I knew, carefully, the way I would think through a case where the facts were unfavorable, but not yet unrecoverable. It was Josephine who told me the rest. Josephine Crane had been my law school study partner and was now at a smaller firm 3 blocks from Hargrove. We had lunch every few weeks, a habit that had survived years of impossible schedules because we had both agreed early on that it was non-negotiable. Josephine was the kind of person who said hard things clearly without performing the saying of them. We were at a Japanese place near her office, the kind where you sit at a counter and the food comes out in courses, and you have to speak quietly because everyone is 3 feet away from everyone else. She set her chopsticks down carefully and said, "Oh, there's something I need to tell you." She had seen Dorian and Delphine at a restaurant in Tribeca on a Saturday night in December. She described how they were sitting in a way that was not professional and had not looked like a working dinner by any reading she could apply to it. She had not said anything in December because she had needed to be certain of what she had seen and because she had not wanted to destabilize something she knew I had spent years building. She told me in March I ate my food through her telling. I thanked her when she was done. I told her she had done the right thing. She watched me for a moment with the expression she had worn in law school during exams. Steady, precise, waiting. You already knew, she said. I knew something, I said. Now I know more. I did not go home that night and confront Dorian. Ozan, I want to explain why, because I think people sometimes read stillness as defeat, or as the carefully banked precursor to something explosive. It was neither. I was a litigator. In litigation, you never reveal what you know before you need to. You never introduce evidence before you have established the foundation for it. You never confront a witness before you have exhausted what you can learn from their ignorance of what you hold. I went home that night, and I was ordinary. I cooked dinner. I listened to Dorian talk about a mediation he had run that week. I asked questions in the right places. I went to sleep. I lay in the dark for approximately an hour before sleep came. What I thought about was not Dorian, and not Delphine, and not the restaurant in Tribeca. I thought about the Caldwell file. I thought about the 8 months Delphine had been in the building. I thought about the specific moves I had been observing and had not yet fully mapped. I thought, she is going for it. Then, someone is going to let her. Then, I need to know what I actually have. There was a specific pattern to what Delphine had done in her first 8 months, and when I laid it out plainly, it was a blueprint that I could read because I had studied institutional architecture for 7 years. The first element, she had inserted herself into 2 meetings with Haverstock in capacities that were peripheral. She had no billing role on the Caldwell account, but she had attended at Dorian's invitation on the rationale that she had relevant expertise in a specific clause type they were dealing with. The meetings had been noted in the file. The second element, she had CEC'd the executive committee on 2 internal memos she wrote, when standard practice was to CEC your supervising partner. Neither memo required executive committee visibility. She was not reprimanded for it. The executive committee now knew her name in association with substantive work. The third element, through a series of small and unremarkable conversations with the junior associates in our group, she had established a reputation as someone who gave feedback generously and who kept people's confidences. She was building loyalty in the layer below her. The junior associates would, if asked, say her name warmly. None of this was extraordinary. None of it was even, taken individually, particularly notable. Together, it was a campaign. And I had been watching someone execute it in the building where I worked, while also, it turned out, sleeping with the man I came home to every night. The meeting with Pemberton was in April. I had almost 3 weeks between the conversation with Josephine in March and that meeting, and I used those weeks the way I use every period before a consequential event. I prepared. I pulled every file I had worked on in 7 years, and I did something I had never done before, which was read my own work as if I were an outside reviewer assessing value contributed. Not looking for comfort, building a picture. The picture was significant. I had originated 2 client relationships independently, small ones, but mine. I had billed consistently above the partnership track threshold for 5 consecutive years. Oh, I had a record of 0 malpractice complaints, 0 client escalations that had not been resolved before reaching the executive committee, and I had received a written commendation from Richard Caldwell himself, a man who I knew for a fact did not write things down unless specifically asked, after a particularly complex regulatory hearing in Houston 2 years prior. I also did something else. I opened a new document on my personal laptop, not the work one, and I began writing down everything I had observed about Delphine in the past 8 months. Not in a chaotic way, in a structured way. Date, observation, context, any witnesses present, whether there was supporting documentation, whether follow-up was required. I was not building a case yet. I was building a framework into which evidence, if it existed, could be sorted. Oh, because here is what I knew from 7 years of legal practice. People who cut corners on their way up do not stop cutting corners after they arrive. The behavior that is efficient and rewarding during the climb becomes habitual. It becomes the way they work. I titled the document Professional Notes. After the Pemberton meeting, I moved to a spreadsheet. Documents are for narrative. Spreadsheets are for patterns. What I was looking for was a pattern, and a spreadsheet's column structure imposes a discipline on evidence that forces you to be specific rather than impressionistic. The columns: date, category, observation, source, supporting materials available, follow-up required. Category was the most important column. I seeded it based on what I already knew and what the rules actually said, because the first thing I did after opening the spreadsheet was reread the model rules of professional conduct in full, not as a refresher. As a reader approaching a text, I needed to apply. Rule 1.5, fees. What constitutes a clearly excessive billing arrangement and how billing records are to be maintained? Rule 1.6, confidentiality. What constitutes improper disclosure of client information and the scope of the duty? Rule 3.3, candor toward the tribunal. What constitutes a false statement of law or fact made to a court or regulatory body, and the certification obligation of the supervising attorney? Rule 8.4, misconduct. The provision that makes dishonesty, fraud, and conduct involving moral turpitude a professional violation, regardless of whether it occurs in the practice of law directly. And Rule 8.3, but which most lawyers know abstractly but rarely think about in active terms, the reporting obligation. A lawyer who knows that another lawyer has committed a violation that raises a substantial question as to that lawyer's honesty or fitness shall inform the appropriate professional authority. Shall. Not may, not should, shall. I read that 4 times. Then I added it to the top of the document as a note to myself, not as a statement of intent, but as a reminder of what my obligations were. I was going to need to know them precisely before I did anything. The first concrete thing I found was a billing entry. I had legitimate access to the billing system. I was still technically on the Caldwell account during the formal transition period, which was running longer than initially outlined because Haverstock had asked Pemberton for a proper handoff, a request that had been made in an email I had been copied on. I was not snooping, I was doing my job. The billing entry was dated a Tuesday in March, approximately 3 weeks before my conversation with Pemberton, for 4 hours of work on a Caldwell regulatory filing that I had completed myself in its entirety the previous week. I had the time-stamped draft saved to the firm system. I had the internal email thread where I had submitted the draft for partner review. I had the version history showing document creation, revisions, and the final submission. The filing had gone out under both our names as part of a collaborative billing entry. That was how the system worked during shared account access periods. But the 4 hours she had billed were for a draft review that had consisted, as far as I could reconstruct from the file, of changing 3 paragraph breaks and removing 2 Oxford commas. I know this because I compared the draft I had submitted with the version she had returned, using the track changes function, which she had apparently forgotten was visible. 4 hours. I added it to the spreadsheet. Date. Category: billing irregularity. Observation: 4-hour billing entry on matter, number, inconsistent with documented contribution to work product. Source: direct review of billing records and file version history. Supporting materials? Yes. A follow-up? Yes. I labeled the supporting materials folder with a date and a filing number, and I saved the version comparison as a separate exhibit. I was not angry. I was methodical. Oh, I want to be careful here because billing disputes are common at large firms and are not automatically an ethics violation. The model rules require a pattern or a degree of excess or a deliberate misrepresentation to the client. One entry, even a questionable one, is not a complaint. One entry is something you watch. I kept watching. The second thing I found came from a different source. A second-year associate named Elena, one of the people Delphine had been cultivating among the junior staff, came to me in May with a procedural question about a filing she had been assigned to prepare. The question she asked was specific. She wanted to know whether the client had consented to a particular disclosure in a filing that would name a third party. It was a good question. It was exactly the right question to ask before filing. Oh, and the fact that she was asking it meant she had read the file carefully and had noticed something that didn't sit right. I asked her to describe the disclosure. She described it. I asked to see the consent documentation. There wasn't any. Delphine had told her verbally that consent was covered. I asked Elena to check the original engagement letter for that specific client matter. She retrieved it. The consent was not covered. The engagement letter had explicit language requiring written client authorization for third-party disclosures, which was not boilerplate. It was a specific client-requested provision. I did not tell Elena what I was thinking. I said calmly, "Before you file, I'd go back to Delphine and ask her to show you the written authorization." Then I added, "Keep a record of the conversation, date and time, what was said, and whether you received any documentation." Elena looked at me for a moment with the expression that second-year associates have when they know they are in a conversation that is more than it appears to be. "Okay," she said. She kept the record. I know because 3 weeks later, she sent me a copy by email with a note attached that said only, "In case you need this." She did not know exactly what was being built, but she was a good lawyer with good instincts, and she understood without needing it explained that documentation mattered. The third significant thing I found was different in kind. It came from outside the building entirely. Josephine had a contact, another senior associate at a firm she occasionally crossed paths with professionally, who had worked at a regulatory boutique years earlier, before that boutique closed. The boutique had handled energy and environmental regulatory work. He had been on a matter there with an associate whose approach to certifications had been, as he described it, casual. I heard this over lunch in June. Josephine was not asking him directly about Delphine. They were talking broadly about firms that had folded in recent years and the reasons behind them, and he mentioned this boutique by way of example. He said there was an associate there who had a habit of certifying to opposing counsel that documents had been reviewed when they hadn't. She told him it saved time. It caught up with them on a transaction that ended up in front of a federal magistrate. There was a complaint, but the parties settled before it was formalized, and the associate had already left. Josephine asked, in that casual way she had, what the associate had gone on to do. He didn't know exactly. "She went to a larger firm somewhere," he said. "Better credentials on paper, probably. That kind of person usually lands somewhere." Josephine put this in front of me at lunch. She said the associate's name. It was Delphine. I did not react visibly. I thanked Josephine for telling me. I updated the spreadsheet that evening. Category: prior pattern, unresolved prior matter. Source: secondhand, credible, supporting materials, none at this stage. Follow-up: research the case record of the closed boutique. I spent 2 weeks researching the boutique. It had closed formally 18 months earlier. Its principal had filed dissolution paperwork with the state bar. The matter that had ended in front of the federal magistrate was technically a confidential settlement. But the magistrate's preliminary order, which addressed the conduct at issue for purposes of sanctions consideration, was a public document. I read the preliminary order. The associate referenced in the order was not named because the sanctions motion had been mooted by the settlement. But the conduct was described specifically enough that I could map it to what Josephine's contact had told me, and the pattern it described, certifying review of documents that had not been reviewed, was consistent with something I knew, which was that Delphine billed time for work that had not been done. The order was not admissible as evidence of her conduct. It was context. It told me this was not a first occurrence. It told me I was looking at a person with a practice, not a person who had made an error. I added the order to the exhibits folder, and I added a note to the spreadsheet. Consistent with observed pattern, establishes prior context, not to be included in complaint without corroborating documentation. The most significant item came last, in late June, and it came not through investigation, but through the ordinary course of my work. In wrapping up a legacy Caldwell matter that was legitimately still mine to close, I read a supporting memorandum that Delphine had filed as supervising attorney of record on a separate regulatory matter in the same practice group. I read it because the matter was tangentially related to a filing I was completing, and I needed to understand the state of the parallel file. The memo cited a federal case as standing for a specific proposition in an argument about regulatory disclosure requirements. I read the cited case because I always read cited cases. This is a habit I formed in my first year and had never broken, because the number of times I had found a case cited for a proposition it did not support was not small. And in litigation, those discrepancies matter. I read the cited case. The case did not stand for the proposition cited. I read it again. The case stood for the opposite proposition, not a nuanced distinction that reasonable people might read differently, not an edge case interpretation that required a stretch of reasoning. The case was clear authority for the opposing position, and Delphine had cited it as authority for her position in a memo filed with a federal regulatory agency under her signature as the supervising attorney certifying the accuracy of the submission. I sat with this for 2 days before I touched the spreadsheet. Rule 3.3, A1 of the Model Rules. A lawyer shall not make a false statement of fact or law to a tribunal. Federal regulatory agencies are, under clear precedent, tribunals for purposes of Rule 3.3. The certification requirement for supervising attorneys on submissions to regulatory bodies is explicit. This was not a billing irregularity. This was not a disclosure procedural gap. This was a misrepresentation to a tribunal in a signed filing. I added it to the spreadsheet on the evening of the second day. Date, category, misrepresentation to tribunal per Rule 3.3 A1. Source, direct review of public filing and cited case. Supporting materials, yes. Follow-up required, no. That was the last entry I needed. I had been quietly talking to other firms since May, not with urgency. Oh, not with the visible desperation of someone leaving a fire, with the methodical low-temperature assessment of someone who knows that what she has is portable and is simply determining where it will land best. The firm I was most interested in was Aldercroft. Smaller than Hargrove, but with a specific reputation in energy and infrastructure work that was, in its particular segment, genuinely stronger than Hargrove's. The partnership track was longer, 12 years, but the equity model was more favorable and the path was more transparent. They did not have Hargrove's institutional tendency to confuse loyalty with subordination. I had lunch in May with one of their senior partners, a man named Gideon Marsh, who had been recommended to me through a client contact. Gideon was the kind of lawyer who asked good questions and then listened to the answers without telegraphing his response. He had built Aldercroft's infrastructure practice over 22 years. He asked me what I was looking for. I said, a place where what I build stays mine. He was quiet for a moment. Then he said, that's not an abstract question, is it? No, I said. We had 3 more conversations in June and July. Each one was shorter than the last because we had covered what needed to be covered, and neither of us was interested in padding the process. The offer came in late July, senior associate with an accelerated partnership review in 18 months, rather than the standard timeline, based on existing client relationships and the specificity of my practice. I accepted in early August. Before leaving, I did something that I want to describe carefully because the line between what is allowed and what is not matters to me professionally and personally. I reviewed my employment agreement. The non-solicitation clause was narrow by design. It covered clients I had originated, not clients I had been assigned. The Caldwell account was Hargrove's client. I had not originated it. I had no right to take it with me, and I was not going to take it, regardless of what Haverstock might have said or thought about the situation. The 2 clients I had originated, a mid-size energy services company and a regional infrastructure fund, were, under the specific carve-out language of the agreement, mine to notify of my departure according to the proper notification procedures. I followed those procedures exactly. I notified Hargrove first, in writing. I notified the client second, in accordance with the timeline specified in the agreement. Both clients moved with me. I gave Hargrove 4 weeks' notice. On my last day, Dorian stopped by my office. I was packing a box, not a dramatic one, just a small one, 2 framed things, and a hardcover of Prosser and Keaton on torts that had been on my shelf since law school. He stood in the doorway with the posture of someone who has rehearsed a statement and is waiting for his cue. He said, "You didn't have to do this." I looked at him. "I know," I said. I picked up the box. I said, "Have a good weekend, Dorian." I walked past him down the corridor and into the elevator and out through the lobby where the security guard, a man who had been at that post since my first year, waved at me from his desk. I waved back. That was Hargrove. And Aldercroft smelled different. Not metaphorically, Literally. Hargrove had the particular smell of a building that had been over-air-conditioned for 30 years. That recycled, neutral, institutional cool that after a while you stopped noticing because it was just the air you breathed. Aldercroft was in a building that was older, and the windows actually opened. In September, the air moved through in the late afternoon, and it smelled like the city. Variable, imperfect, real. Gideon introduced me to the practice group with the kind of low-ceremony confidence that signals an institution that does not need to perform itself. No elaborate welcome presentation, no formal onboarding theater, a desk, an access card, a meeting with the 3 partners in my group, and a brief "Cressida is joining us from Hargrove to lead energy regulatory," delivered with the flat confidence of a fact that he expected everyone to simply accept. I accepted the desk, I set up my access, I had my first client meeting within a week, and my first filing within 10 days. And by the end of the month, I was in the middle of a regulatory dispute that was, in its technical specifics, exactly the kind of work I had been doing for years. And I was doing it now as the person at the front of the room rather than one layer behind the person at the front of the room, which changes how your brain engages with a problem in ways that are difficult to explain, but immediately, physically apparent. In my 3rd week, now's on a Wednesday evening when the office had largely emptied and the city was doing its early autumn thing outside the windows that actually opened, I filed the Bar Association complaint. The complaint form is deceptively simple. It asks for contact information, the name of the attorney being reported, their bar number, the jurisdiction, and a narrative description of the alleged conduct with attached documentation. The form is 4 pages. What I filed was not 4 pages. My complaint was 26 pages, plus exhibits organized into 4 tabbed sections. The narrative described each incident in chronological order with specific citations to the model rules. On billing irregularities, 6 documented instances across a 3-month period, each identified by date, matter number, billing entry amount, and the discrepancy between the entry and what the file record could support. I included the version comparison from the very first entry, the one with the track changes, as Exhibit A. The other 5 followed in order, each with its own exhibit. On confidentiality, the 2 incidents, with full documentation. Elena's contemporaneous record of the conversation, the engagement letter provision requiring written authorization, the text of the actual disclosure, and a brief analysis of the gap between what the client had authorized and what had been filed. I did not name Elena. I identified her as junior associate, date of hire on file with the firm. Her record was documentary evidence. Her name was not necessary for the complaint to be specific. On misrepresentation to the tribunal, this section was the longest. I reproduced the relevant paragraph of the memo with the citation highlighted. I reproduced the cited case's actual holding, underlining the operative language. I wrote a 2-page analysis demonstrating, citation by citation, that the case stood for the opposite proposition. I identified the filing as a submission to a federal regulatory agency. I cited 3 cases establishing that federal regulatory agencies qualify as tribunals for Rule 3.3 purposes. I noted the date the memo had been filed and Delphine's signature as supervising attorney. On prior pattern, I included the magistrate's preliminary order from the boutique matter, flagged clearly as contextual rather than evidentiary, and with a note that it was included solely to establish that the conduct in question was consistent with a documented prior pattern of practice rather than an isolated occurrence. At the end of the narrative, before the exhibits, I wrote 1 sentence. The pattern of conduct described above reflects not isolated errors, but a consistent approach to professional obligations that places the interests of the attorney above the interests of clients, opposing parties, and the accuracy of representations made to tribunals. I submitted the complaint at 8:47 in the evening. I drove home, I ate dinner, I slept at a reasonable hour. October was ordinary. I was building the practice at Aldercroft. The energy regulatory work was substantively interesting in a way I had not experienced in some time. Odd because the problems were mine to solve from the beginning rather than mine to support from the middle. I was also beginning to understand, in the particular way you understand things only after you are no longer inside them, what the last 2 years at Hargrove had cost in terms of concentration, the ambient noise of watching the partnership door, watching Dorian, watching Delphine's position in the institution, all of it running quietly beneath every workday like a second process consuming memory. That noise was gone. I thought about Dorian occasionally, but not with the raw daily quality I had braced for in September. More the way you think about a decision you've made and tested from several angles. Sustained, practical, final. He called twice in October from his work phone. I did not answer, not as punishment. Because I had nothing useful to say, and the conversations I could imagine having would not serve either of us. In November, he sent an email. He said, among other things, that he had ended things with Delphine. I read the email. I considered what he expected me to do with that information and what it revealed about how he understood me. I wrote back a single line. I appreciate you telling me. That was our last communication. In December, I received an acknowledgement letter from the Bar Association's Office of Attorney Ethics. The letter confirmed receipt of the complaint and stated that it had passed initial screening and been assigned to a staff investigator. Screening is the first filter, and it is not trivial. Complaints that lack specificity, documentation, or a cognizable rule violation are dismissed at this stage without investigation. A complaint that passes screening has been reviewed by a staff attorney who has determined it is not frivolous and warrants inquiry. Mine had passed. The letter did not confirm timeline or outcome. It was formal and procedural. It told me, we have received this. It is real. It meets the threshold for investigation. I put it in the same folder where I kept the exhibits. I told one person, Josephine. She asked if I felt anything. Relief, mostly, I said, and a specific satisfaction that the filing held up. She laughed the way she laughed when something was funny in a dark way that both of us understood completely. Esmeralda Gideon stopped by my desk in mid-February to tell me that a client had specifically requested that I lead their representation on a new matter rather than working under him. The client was a mid-sized energy company in the middle of a federal regulatory dispute that was, in its technical contours, exactly the kind of work I had been building expertise in for years. The dispute had 3 overlapping jurisdictional questions that made it the kind of matter that most general practitioners would not want to touch. I wanted to touch it. This is going to be significant, Gideon said. The Westmere matter. Are you comfortable leading it? Yes, I said. He nodded. Then, almost as an aside, when you came in for that first lunch back in May, I wanted to ask you something and I didn't. I waited. I wanted to know why someone with your record was quietly looking elsewhere without making any noise about it. It struck me as very careful. It was, I said. I wasn't going to pry, he said, but I recognize careful when I see it. He walked back to his office. That was all he said, and it was enough. In March, approximately 5 months after I had filed the complaint, something changed at Hargrove. I heard this through 2 sources in the same week, neither of whom knew the significance of what they were reporting to me. The first was a lateral associate who had joined Aldercroft from Hargrove in January, who mentioned casually that there had been some kind of audit situation with the Caldwell billing that had made the group uncomfortable. The second was Josephine, Anand, who heard from her contact at the other firm that one of Hargrove's litigation partners had been asked to review a regulatory filing from the energy group by outside counsel for an unspecified reason. Outside counsel review of an internal filing is not routine. It happens when there is a specific concern about the filing's accuracy, and the firm is conducting an internal audit in anticipation of a professional liability exposure, meaning someone outside the firm has raised a question about the work product, and the firm's response is to find out how bad the answer is before the question becomes louder. The investigation had reached a point where the bar's investigators had contacted someone, a client representative, a third party, someone positioned to verify the content of the filing, and what that contact had revealed had caused Hargrove to begin its own parallel review. This is how these things move. The bar talks to someone. That someone is now in a position where they have information they did not previously know they needed to have. The firm finds out there is an investigation, and the firm immediately starts trying to understand the exposure. In April, Elena called me on a Monday evening. She said, "There are people from the state bar at Hargrove. They were in Pemberton's office." I asked if she was all right. She said she thought they were going to speak with her about the consent documentation issue. I said, "When they do, tell them exactly what happened. Don't embellish. And don't reduce. Oh, tell them what occurred and show them the record you kept. She was quiet for a moment. Then she said, "Was this you? Did you file something?" I said, "You kept a contemporaneous record of a conversation that was relevant to a potential ethics issue. You did that independently, on your own judgment, because you were a good lawyer who knew what mattered. What happened afterward is the process doing what the process exists to do." She didn't push it. "Okay?" she said. "Thank you." She handled her interview without help from me. She answered their questions clearly and presented her documentation, and the investigators went away with what they needed. She was a good lawyer. She did not need me to manage it for her. In June, Dorian called on a Saturday morning from his personal cell phone, which was different from the calls I had not answered in October. I answered. His voice had a quality I had never heard in it before. Restraint layered over something that was not entirely restrained. He said, "They've put Delphine on administrative leave." I said, "I heard something to that effect." A pause. He said, "Did you file a complaint?" I said, "I reported conduct that I believed violated the model rules of professional conduct. I was ethically obligated to do so under Rule 8.3. Rule 8.3. A lawyer who knows that another lawyer has committed a violation that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness shall inform the appropriate professional authority." Shall, not may. Another pause. Longer. He said, "Was this the whole time? Wait, was this?" I thought about what the honest answer was versus the kind answer versus the accurate answer. I documented what I observed. I said, "I filed when I was at another firm and had no conflicting professional obligations." "That's not what I asked," he said. "I know," I said, "but it's the answer I'm giving." A moment. Then, "She's going to lose her license." I said, "I expect so, yes." I said it the way you state a legal conclusion after analysis. Not with pleasure, not with theater. He hung up. I thought about him for about an hour after that call. Not with anger or with grief, but with the specific quality of attention you give to something you have been close to for a long time and are now seeing clearly for the first time from a distance. What we had built was real. I still believed that. And it had also been real that he had made a choice, and then leveraged that choice to position someone within the institution we both belonged to. And that positioned person had done things that harmed people she was obligated to protect. A sequence of consequences. You cannot choose the sequence and then decline to own the end of it. Administrative leave at Hargrove meant Delphine was suspended from practice pending the investigation's outcome. She retained her office, technically, and her salary on a temporary basis that I knew from industry knowledge was not likely to last more than 30 days before being quietly restructured. The partnership vote, the one that had been scheduled in her favor, the one that had displaced mine, was tabled. I learned this from the lateral at Aldercroft, who told me over lunch in June as industry gossip, but with no idea that he was reporting it to the person most directly connected to the situation. "Messy situation over at Hargrove," he said. "One of the senior associates on the energy team is under a bar investigation. Sounds like a billing thing, primarily?" "Billing things are rarely just billing things," I said. He shrugged. "True enough. Shame. Apparently she had been on a fast track. Good credentials on paper." "Paper is like that," I said. We talked about something else. July came in hot. The Aldercroft office was on a high floor, and the windows open policy that I had appreciated in September became, in July, something you negotiated with the cross breeze and your own tolerance for humidity. And I was deep in the Westmere matter, the regulatory dispute Gideon had asked me to lead, and it was the kind of work that required the full capacity of your concentration, the kind of problem where you are balancing 17 interdependent questions, and the goal is to find the sequence of resolutions that does not create a new problem while closing an existing one. I was good at this. I had always been good at this. I was better at it here, at Aldercroft, than I had been in the last 2 years at Hargrove, for reasons I have already described and will not repeat. On a Tuesday in the last week of July, I received a letter from the Bar Association's Office of Attorney Ethics. It was brief. Final determinations are brief, because a final determination requires no elaboration once stated. Oh, the letter informed me that the investigation into the attorney identified in my complaint had concluded. The disciplinary board had determined that the conduct described in the complaint and established by the investigation constituted violations of Model Rules 1.5, 1.6, and 3.3, A1. The board had further determined, based on the totality of the record, including findings made during the investigation that were supplementary to the complaint, that disbarment was the appropriate sanction. The effective date was 14 days from the letter's date. I read the letter twice. Then I did what I always do when a matter resolves. I updated the file, I created a new document in the Exhibits folder, and saved the letter there, labeled Final Determination. I closed the folder. I opened the Westmere file and went back to the brief. At lunch, I called Josephine. She answered on the second ring, and I said, "It's done." "The final determination?" she said. "Yes." She was quiet for a moment. Then, "How do you feel?" I thought about it properly, not reaching for the first word that appeared. I was sitting in a Thai place 3 blocks from Aldercroft that had 8 tables and a laminated menu and food that was excellent because the menu was short and everything on it was made with attention. I had pad CEW. The city was moving outside the window. "Satisfied," I said. "With the process, with the accuracy of the documentation, with the outcome." "Not vindicated?" she said. "Not something more?" "Satisfied," I said again. The conduct was real. The documentation was accurate. The rules existed. The outcome followed from the material. She said, "Oh, that's very Cressida of Yoshu." I took a bite of my food. "I know," I said. She said, "Can I be less measured on your behalf? Just for a minute." I said, "Please, so what she said I will keep between us." But she said it with feeling and without performance, and I listened to all of it, and it was good to be heard by someone who had been there from the beginning and who understood the full shape of what had been required. I want to say something about Delphine. Precisely. Before the end, because precision is what I owe the record. She did not lose her license because I had been wronged. She lost her license because she had made false representations to a federal regulatory agency, had maintained billing records that did not accurately reflect services rendered, and had disclosed client information without authorization. These are the specific things. The model rules existed to protect the people who relied on lawyers to do their jobs honestly. The investigation established that she had not done her job honestly. The complaint I filed was not an act of personal justice. It was an act of professional obligation, filed when I had the standing to file it, and the documentation to make it specific. The outcome was not personal. It was the process doing what the process exists to do, which is hold the bar to its own standard. I had built a precise, documented complaint. The bar had investigated, the evidence had held under scrutiny, the determination had followed from the facts. That is what happened. And in September, exactly 1 year after I'd left Hargrove with a small box and a wave at the security desk, Gideon called me into his office formally for the first time. He told me that the Partnership Review Committee had decided to move up my review to 6 months rather than 18. There had been a conversation about my originations, my client retention, and the Westmere resolution, which had come out in the client's favor and had been noted in a trade publication with the kind of brief, unadorned coverage that legal trade publications reserve for outcomes that are genuinely technically significant. He slid a document across the desk. "The partnership offer," he said. "Take the weekend if you need it." I looked at the structure of the offer. The equity percentage, the draw arrangement, the client origination credit, the billing floor. It was significantly better than what I had been tracking toward at Hargrove in the year before I left. Not comparable, different in kind. "I don't need the weekend," I said. He looked at me with the expression of someone who had expected exactly this response. "All right," he said. I signed it at his desk. The Caldwell account left Hargrove 3 months later. I did not solicit it. Haverstock called Aldercroft's managing partner directly through a channel that had nothing to do with me and asked to have a conversation about the firm's energy regulatory capacity. Aldercroft put me in the room for that conversation because I was the practice lead and because I had the history. I sat across from Haverstock in Aldercroft's conference room, an ordinary room, a good table and adequate light, and no view engineered to make anyone feel consequential. And he said, "You know, I told Pemberton at the start of all this that transitions are never clean." I said, "He's a thoughtful man. I'm sure he took that seriously." Haverstock looked at me, the expression of someone deciding how much they want to say. He said, "We'd like to move the account." I said, "We'd be glad to have it." The paperwork came through 2 weeks later. It was October when I ran into Dorian. Not dramatically, not at someplace with meaning. At a coffee counter near a courthouse in Lower Manhattan where I had been for a hearing, and where he was, apparently, also coming from one. He looked the same, a little less polished than I remembered, which might have been the day, or might have been something that had been running longer than the day. He stopped when he saw me. I was already at the counter. I ordered. I stepped to the side. He came to the counter and ordered. He stepped to the side. We were standing next to each other. He said, "You look well." "Thank you," I said. He said, "Aldercroft, I've been hearing good things." "That's kind," I said. The barista called my name. I took my coffee. "Cressida," he said. I turned. He had the expression of a man who had prepared a statement and had been holding it for a long time. I waited. He said, "I'm sorry for what I did, for the choices I—" He stopped. "I'm sorry." I looked at him. "I know," I said. I put my coffee in my bag. I walked out. The paper cup was warm through the sleeve. And the October air outside was the particular cold that is not winter yet, but is making a specific point about what is coming. I turned east. I had a call with Haverstock at 2. A draft brief due Friday on the secondary Westmere matter. A new client consultation Monday morning. A referral from a Chicago firm that had heard about the Westmere result and wanted to discuss a similar federal regulatory dispute in a different energy sector. I walked. The city was loud and ordinary around me. I was already thinking about the brief.